Hello and welcome to the Ahaki podcast. On this special series, we focus on litigating sexual reproductive health and rights across Africa. We're hearing from different countries in a South-to-South exchange discussion. On this particular episode, I am privileged to be hosting Khanyisa Mapipa. Khanyisa Mapipa is a human rights lawyer and advocate of the High Court of South Africa. She is also the head of the Human Rights Program at Section 27, a civil society organization in South Africa. A very warm welcome, ma'am. Thank you so much for joining us for this podcast.
Thank you for having me.
Great. Let's talk about South Africa, a country that has been described by many as progressive. Let's talk about by perhaps taking us into how the legal and policy framework looks like in South Africa in as far as litigating sexual reproductive health and rights is concerned.
All right, so abortion is legal in South Africa under our Choice of Termination of Pregnancy Act. It stems from our constitution, actually. So under Section 27 of our constitution, you have the express right to access to health care, but it specifically states that you also have the right to reproductive health. So it says everyone has the right to access health care, including reproductive rights. And what I like to say is that clearly shows that our drafters of our constitution were quite feminist, because they could have indicated or included anything else, but they made sure to indicate that these rights include reproductive rights. And then again, in our constitution, you see the right to reproductive choice appear again under Section 12 of our Constitution, which gives you the right to bodily autonomy, including the right to reproductive choice. So together with these two rights, Section 27 and Section 12, our legislature then came up with our Choice on Termination of Pregnancy Act, which really gives us the outline of how abortion should be handled in the country, who can provide abortion services, when a woman can request those services, and things like consent and counseling are also regulated under the Act. Further to that, we have guidelines, clinical guidelines, that speak in more detail to healthcare providers and doctors and the like, as well as midwives, on how they actually are meant to administer this service. So that is, in broad terms, the legal framework that encapsulates abortion rights in South Africa.
Yeah, and a much broader level, sexual reproductive health and rights. It's interesting because that's a little bit different from Uganda, where that right is on conditions of the health of the mother. But it's interesting how South Africa moved past the penal codes that were established already in our jurisprudence, which is much of common law and laws that were set up by our colonizers. There's a general conversation in Africa on decolonizing our legal and policy framework in our African countries. It looks like that South Africa has now made a progression towards that.
Yes, certainly. Abortion rights in South Africa are actually something that predates our democracy. So we initially, in the 1980s, had our Abortion and Sterilization Act. But under that act, only white women were allowed to have abortions, and these services were only afforded to white women. And so obviously it cut out a greater number of the population, being black and colored and Indian women, from accessing abortion services. But with the advent of our democracy and bringing in democratic rights and bringing in a more progressive and inclusive a realization of sexual and reproductive rights, we saw the creation then of our current act, which is the Choice on Termination of Pregnancy Act. And so in that negotiation process, the drafters of our constitution, as well as the drafters of our act, were then able to decolonize this exclusive right that was only seen or only protected white women from death as a result of complications in pregnancy. So they were able to then abort or have that procedure done to preserve their lives.
It's interesting because how was the process like, by the way? Amidst cultural, religious, and all these backgrounds in the process of decriminalizing or in the process of decolonizing the legal and policy framework around access to sexual reproductive health and rights services and broadly SRHR.
Yeah. So one thing that I like to say when I'm doing, presentations or training on abortion rights or sexual reproductive health rights is that when a woman wants an abortion, she will have an abortion. It is not about whether it is legal or illegal. It is not about the morality of the country or the society at that point. It is about her choice, and she will have that. And that's exactly what was happening before abortion was extended to include everyone else in South Africa. Is that women in these communities, the Black communities, the colored communities, were having abortions. It was something that was being done, even despite it not being included in the law. And so bringing it into a legal framework just made it allowed those women to be validated in their decisions, allowed them to have the choice that white women had at the time. So abortion is not something that's new or that women started doing just because it became legal. It's something that women were doing long before, and of course in an unsafe way because it wasn't done by medical professionals in the light of the law. But having it, being legalized or having it being protected by the law allowed women to be safer in that environment and allowed them to have it in an environment where they could get the advice of medical professionals on what complications they can expect and the like. And so it was really just a way to save their lives and not necessarily to encourage them to have abortions because they were doing that anyway.
Yeah. No, as I'm listening to you, we're talking about, the Afrocentrism around our legislation and legal framework in as far as sexual reproductive health and rights. There's been conversations on that if the law is made to be open like it is in South Africa, it will increase the number of people who are getting abortions. And there's so many people I've talked to have said, but the science doesn't speak to that. The research doesn't bring to that. In fact, it actually shows otherwise. How have you been able to navigate these narratives in South Africa?
Yes, so quite astonishingly, even with our progressive laws, a number of women actually don't know that abortion is legal in the country. So the 2019 statistics, as indicated in our guidelines or the forward in our guidelines on clinical guidelines on the implementation of the Act, show that about 50% of women in South Africa were actually accessing abortion services in an unsafe way using backstreet abortion services because they don't know that abortion is legal in the country. So that just goes to show that there's actually not much resources and not much conversation that's being had by our government, by our healthcare providers with women to explain that this is something that is legal, this is something that is your right, this is an option for you. You can approach any facility and get this service. So that statistic in itself is quite scary, that about only 50%
that's crazy.
is accessing safe abortion services. And it's honestly because the backstreet or unsafe abortion providers are so loud in their advertising. If you walk in any metropolitan area in South Africa or any city, in actual fact, you'll see a number of these adverts that says free and safe abortion services, and it's like a number at the bottom where you can call someone, and it's understood that it's a what we call an illegal provider who's doing it. And so those are the people that are louder. And so obviously women start to think, oh, okay, it must be because it's illegal to do it. It must be because it's something that's, should be done on the down low, on the hush-hush. And not actually knowing that they could walk into a healthcare facility, a safe environment, and get it done in a sterile manner.
And that, in a way, increases the burden on government for post-abortion care. I mean, 50% is quite a huge percentage. And many of these sometimes may go wrong and find themselves in public health facilities seeking access to post-abortion care.
Exactly. A number of them do, actually. So this is also one thing that we say to government when we are advocating for further resources for this right. The right is actually under-resourced significantly in our healthcare facilities. There's a province in South Africa called the Eastern Cape, and it's got about 6 million people living there. With a population of half of that population being women, so about 3 million women. And of those 3 million women, they have to seek second trimester abortion services at only 2 facilities. So they only have 2 facilities in the whole province, which is a vast province, where they can get these safe services. So as much as our government can say that they are ticking the box to, we have facilities that provide these services. In actual fact, if you have 3 million women depending on 2 facilities, you are denying them the access to that right. Even at those 2 facilities, they only have about 2 beds in those facilities, so about 4 in total that allow for second trimester or are designated for second trimester abortions. And so the waiting periods are weeks and weeks and weeks. On average, a woman who is in her second trimester will have to wait 7 weeks before she sees the inside of a hospital in order for her to get her procedure. So if you're a woman in your 13th week, which is when the second trimester starts, and you approach this facility for one of the 2 facilities for abortion services, you will be told that you have to wait 7 weeks, which pushes you to the edge of the time when you are allowed to have an abortion. Of course, abortion becomes illegal after the 21st week, or becomes legal under very tight circumstances.
It's even dangerous.
It's even more dangerous. And so if you approach at 13 weeks, you have to wait until your 20th week to access this service. So, the question that we always pose is that, can you actually say that you are providing a accommodating environment, an environment that is allowing women to access this right, if you're limiting resources so much that they have to wait their entire second trimester before they can access the services?
Wow. All right. Thanks for sharing those views. But you are an attorney. You have gone to courts. Which cases stand out in South Africa, and how has it been like to litigate SRHR-related cases in South Africa?
It's been tough. The first case that we had that relates to the choice of termination of pregnancy services. When she approached our offices, she was 20 weeks, 1 day pregnant, and the time in order for you to get a second trimester abortion lapses at 20 weeks, 6 days. So after that, you can only get an abortion if the life of the mother is threatened, or they are severe. There's a severe chance that, or a high chance that the fetus will have fetal abnormalities. Those are the only 2 reasons why you can have an abortion after the 21st week. And so she was fast approaching that deadline. And it's not because she hadn't tried. So before then, she had approached a number of health facilities seeking these services. She had gone a number of times asking healthcare providers to assist her. And each time she was turned away. And at times, they would abuse their own medical knowledge to try and dissuade her from making the decision. The first time she went, for example, she was told that she needs parental parental consent, something that we know under our Choice of Termination of Pregnancy Act, in terms of Section 5 of that act, you are not, as a woman, required to get consent of anyone. And as a minor, you are encouraged in terms of the act to seek the guidance or advice of a friend or a family member, but it specifically says that you should not be denied that opportunity to get an abortion should you not wish to get that advice or support. And then the second time she went to a facility, she was told that the fetus was breached or was sitting in a position where she wasn't going to be able to get the abortion. Of course, our experts in the case could prove that at that point in her pregnancy, it was so early on that even if the fetus was in that position, that would not prevent an abortion. And that is what I mean by saying that the abuse of medical knowledge to try and dissuade women from making a decision is what we're facing in terms of barriers to access in South Africa. And obviously that is driven by stigma. And then the last is that the last time that she went, she was actually told that she was beyond the period allowed legally. And of course, like I said, when she approached our offices, she still had 5 days to get the procedure done. So we immediately wrote to the Department of Health to say that this is a situation, this is the issue that we're facing. Can you have someone perform this procedure on her within the next 5 days? They wrote back to say no, they cannot. Their doctors are not working at this point, and so they basically refused to access to the right. We then had her psychologically assessed because there was obviously issues around family pressure and things of that nature. She was at the time homeless when she approached our offices because she had been kicked out of her family home because of falling pregnant, and her family had said, don't come back unless you're not pregnant anymore. And so we worried that those situations were perhaps coercing her into making a decision, and so we wanted to take instructions from her, knowing exactly what she was instructing us to do. Once we had done that evaluation, we then were able to take the instructions from her. We had a social worker sign off that she was capable of making that decision and understood the gravity of the decision and what it entailed, and then we were then able to represent her. We then had her evaluated by a gynecologist and a midwife, and presented all that evidence to court. So we were in court on the Friday evening. We filed our papers, and we were heard on the Saturday morning with the Department of our Department of Health responding with their own papers. So it's just I just want to clarify one of the questions that I had heard earlier when I was discussing this topic was, how is it possible to get into court on a Saturday?
I was almost going to ask, so do courts work on Saturday?
Yes, so our courts are open 24/7 technically,
24/7?
and 365 days a year. We have what we call urgent court, which is for specifically like really urgent matters. So this is if a child is being taken out of the country by another parent and another parent is trying to interdict them from doing that, and it cannot wait. The flight leaves in a few hours. We have a judge on call. So we have something called an urgent court phone, and it sits with the urgent court judge, and you can call that number and someone will pick up and your matter can be heard within hours and sometimes even minutes. So we do have the luxury of that system, and that's what we used in this case to be able to get into court so urgently. And so anyway, we were heard on the Saturday, and something that is quite interesting about this case is the role of patriarchy or the patriarchal mindset in determining these kind of cases. So our judge was a white male judge who would not let us proceed without having firstly satisfied himself that the parents of the minor were aware that she was seeking these services. And so he required an affidavit from the mother expressly saying that she consented to the procedure, even though the law specifically says she does not require consent. The judge in the case was unwilling to give us the judgment unless he was satisfied that the parents were aware.
With the affidavit.
Yeah, exactly. And so the other issue was that, so we brought our application on 2 grounds. The first ground being rape. So the minor was 14 and the person who had impregnated her was 21. And so in our country and in our law, consent for sex can only
18?
occur at 16.
16.
Oh. Yeah, and so so she had been a victim of statutory rape, and so we brought our application under the section of the Act that allows for second trimester termination of pregnancy if the pregnancy occurred as a result of rape or incest. And then the second ground that we relied on was the ground that says that the continuation of the pregnancy, if the continuation of the pregnancy will adversely affect the woman's socioeconomic circumstances, then she's entitled to a second trimester abortion. So we used those 2 grounds and relied on them in our application. We failed on the first ground of rape because the judge was not convinced that rape in the circumstances was what the legislature had envisioned when they said that rape could be used as a ground for abortion in the second trimester.
Did he say that it was consensual sex or what?
He expressly said that statutory rape has an element of consensual of consent, and therefore he is not convinced that that is a ground, statutory rape is a ground under the Act, which is something that, I think would be common knowledge that rape is rape. And
it sets precedents.
And exactly. And this is what I mean when I say that the role of patriarchy and the role of toxic masculinity, if you will, and the role of men who sit on the judiciary and who decide these kinds of cases, and not fully understanding what these terms mean, is a danger to the realization of these rights, because as we argued in the case, there's simply no way that the reading of the Act where it says rape cannot include statutory rape, because by the very definition of statutory rape, the person being raped does not have the capacity to consent. And so we failed on that ground, but we had to quickly move on because, what was at stake here was this little girl's future, if you will. And so we relied on the second ground, which is the socioeconomic circumstance. And for that, the judge required that we get a psychologist and a psychiatrist to evaluate her, and that we also get the parents to attest to the socioeconomic circumstance of their environment. And we obviously then also relied on scholarly information regarding the ability of young girls who have fallen pregnant and are young mothers to return to school, for example, to get gainful employment, for example, to lift themselves out of poverty, right? So the data is quite clear on that, and we used a lot of that evidence to support the case. And then, of course, we were able to get the testimony of the parents, and then, of course, the testimony of psychologists and psychiatrists, which I might add was quite difficult to get on a Saturday on an urgent basis, to have them evaluate her and write a report, a thorough report, for us to be heard again on the Sunday. But I'm happy to report that we were able on the Sunday to be heard, file our evidence, and then get the court order that we needed.
It's interesting. It's an interesting story, and the whole barriers that you had to go through to ensure that the law was interpreted in your favor, because I think judgments are an interpretation of the law and the decisions made on that. Any lessons to learn from South Africa for the rest of Africa?
Yes, I think the major lesson is that I understand, that some of the jurisdictions are not as progressive in terms of the laws, and the attorneys and the lawyers who are working on the cases here to try and push those barriers to ensure that it is ultimately included in the law are doing amazing work. But I would just say that it doesn't end there, because as you can see, in South Africa, we have the law, we have the guidelines, we have everything to support it, but we don't have the implementation. The implementation is what is important in terms of realizing the right. And even if you get the right, even if you get it in the books and it's written in black and white, it might still not be something that you are able to access if it's not something that you push and you continually advocate for. It is a right that will always be at risk. And so while you're pushing these gains and celebrating the wins, you have to continue fighting. At every turn, you have to continue fighting, because unfortunately, the barriers lie in the minds of the people who control the access to the right? It lies in the stigma that we all carry with us. It lies in the stigma that healthcare workers carry with them. It lies in the stigma that politicians who have the ability to allocate resources towards the realization of the right, it lies with them. It lies with members of our society where women exist and young girls exist, with their teachers, with their mentors, people in their community, with their traditional leaders. And so we really have to keep going, and we really have to keep pushing, even beyond getting the law on the books.
I understand. And that may require bringing on board for example, the judges through consistent sensitization, through working with them to show them, it's one thing, sitting behind there, but you also have, preconceived minds, prejudice.
Exactly.
Are you bringing on the bench, like are you bringing judges to these constant, training sessions and advocacy sessions?
We hope to. We haven't yet. Leaning on those stakeholder relationships, the importance of bringing on board media, because oftentimes, in my work, at least in South Africa, we're often scared to bring on media because of the stigma and all of that surrounds abortion. So we do it in a hush-hush manner and then report on it later. But it could be quite a useful tool in our advocacy, a tool that we use in other areas of our advocacy all the time, but just feel unable to when it comes to abortion rights. So definitely something I've learned, and that's something that I've taken away from this engagement that we've had over the past few days, and something that I'll be taking
including the judges.
Yes. Exactly. Including
I think
the
they need constant training.
Yes. And
conversations. You've talked about the patriarchy, but if you really told them, when they're out of their robes, try to argue with them in a safe space where you can say, look, these are the facts. This is what the data says. So even when they put their robes back on, they look at it differently. I think judges are humans before they become judges. They're part of the social constructs. They're part of the cultural beliefs and the religious beliefs. And I think deconstructing that and helping them and bring them on board to understand the subject in a more comprehensive manner. The case that you just gave, it was urgent. But the fact that you're pressing for more, you're trying to, there's something that underscores that.
Yeah. Exactly. There are human beings and mothers and fathers and all of that before anything else, and they might have that as an influence when they're deciding these types of cases. And I think it is important to have these discussions with them.
All right, where do we go from here?
So we're trying to develop the right, and we've been working with communities in three of our regions in South Africa, in the Eastern Cape, as I've mentioned, and Limpopo as well as in Gauteng. We've managed to publish reports on the state of abortion in those provinces and engage the departments, the provincial departments of health. Unfortunately, if those don't lead to any kind of resolution, we will have to litigate. So we are looking at a strategic litigation, whether that would be something that would be possible or something that would be necessary. But I can't speak too much on that at this point. But so we're looking definitely to speak a little bit more to the resource allocation when it comes to this right, and have that discussed or ventilated through the courts.
Thank you. Senior Khanyisa Mapipa, thank you so much for speaking to us.
Thank you.
Yeah, it's great hearing about what's happening in South Africa. Thank you.
Thank you.
Mrs. Mapipa is an advocate of the High Court of South Africa. She's also the Human Rights Programs Manager at Section 27. I hope that you've learned a thing or two. Thank you so much for being part of the Haki podcast. I'm Solomon Serwanja.